All right. If you are looking for a fireside chat about the North Carolina Board of Dental Examiners versus the FTC Supreme Court case, you are in the right spot. So excited to have you today. Dr. Feingold and I are just going to give it a minute or two to let all of the attendees join. We've got a huge audience today. We're so excited about the level of participation here. It's going to be an amazing chat. So I'm just going to give it right until 12 p.m. Eastern, actually, to let everybody kind of file in so that we don't kind of get started without anyone. But thank you all so much. Welcome, welcome. We'll get started in about 20 seconds here. All right. You doing all right, Dr. Feingold?
Yeah, it's kind of warm here in North Carolina for a fireside chat, but I'm glad to do that, glad to be here.
Good. It is a little warm. And you know what? I think you're my first panelist where we're actually both in the same place because of course I'm in North Carolina too. So that's pretty cool. So
Oh, yeah, that is.
it is a little bit warm though. You're right. All right, everybody, we are at, Beverly, snowing in Canada. I'm so jealous. I wish I had snow, Beverly. I know you're tired of it. I would love it. Just saw that come through on the chat. All right, it's officially 12 p.m. Eastern. I want to thank everyone so much for being here today. If this is your first time being part of one of CERDME's regulatory fireside chats, welcome, and thank you so much for your participation. My name is Mary Alice Olson. I'm the SVP of Client Services with CERDME, and I also lead licensing strategy because I'm a former regulator for almost a decade. Regulation is where my heart is. So my goal is to bring fantastic speakers to you on a monthly basis where we can all kind of learn something new and really develop a connection in the regulatory community across professions, which is super cool. So today I'm very excited to have with me Dr. Cliff Feingold. He is the Secretary of the American Association of Dental Boards, or AADB, and a future president of AADB. I'm doing a little crystal ball work there, but you'll see very quickly how impressive he is and how impactful he has been in the dental community and the regulatory community. So I think it's safe to say he's also a future president of the AADB. And just so everybody knows, that is the national regulatory body for dental boards, right? All the dental boards are actually members of that organization. So very impressive organization that I've been really lucky to be involved in recently. So a few kind of introductory remarks about Dr. Feingold. He's going to be helping us understand the landmark Supreme Court case from 2015 that was between the North Carolina Board of Dental Examiners via the FTC, which, as you all know, just sent ripples throughout the regulatory community. I can't tell you how many conference sessions I've been to about, oh my goodness, what are we going to do now that this ruling is passed? What does this mean? How do we structure our boards? Do we have too many public members, not enough public members, too many practitioners on the board? Just a million questions, right, pops up as a result of this case. And what's really neat is I've never had the opportunity to actually talk to someone who was in the thick of it. So a little bit about Dr. Feingold's background. He served as the member of the North Carolina State Board of Dental Examiners from 2005 to 2008, and then again from 2012 to 2018. And then he was actually president of the board from 2015 to 2016. So he was right there when all this action was happening. So we're so grateful he's with us today. And thank you so much to those of you who have sent in some questions in advance. We're going to save some question time at the end, about 5-10 minutes of the 30 minutes we have today. So thank you so much for your participation. Please feel free to send those questions in throughout the chat. So with that, I will be quiet and say, Dr. Feingold, thank you so much for your time today and being here with us.
Well, thank you, Mary Alice. How are you all doing? I'm sending greetings from Asheville, North Carolina. First, I must state a disclaimer. I am not a lawyer, I'm a dentist. So to begin with, the FTC case began when the North Carolina Dental Board began receiving complaints from dentists, dental hygienists, and the public about operations of tooth whitening services provided by non-dentists, primarily in shopping center kiosks. At least 4 members of the public complained they've been harmed by these providers. So the board sent letters stating its belief that tooth whitening by non-dentists violated the North Carolina statute that declared the removal of stains, deposits, and accretions from human teeth constituted the practice of dentistry and required a license. The letters also invited the providers to respond if they had evidence that their services did not violate the North Carolina statute. And the board also sent letters to several mall operators indicating its belief that the tooth whitening was the practice of dentistry and as such required certain sanitation and infection control standards to be met where such services were offered. The letters discouraged mall operators from renting space to tooth whitening kiosks. The board took all these actions based on its purpose to protect the public and uphold the North Carolina statutes. However, it is important to note that the North Carolina Dental Practice Act did not specify the words bleaching was the practice of dentistry. But as noted, the statute did say that the removal of stains, deposits, and accretions from the human teeth was the practice of dentistry. Herein lies one problem that faces a lot of regulatory boards. The statutes, laws, regulations, and rules that we uphold do not necessarily keep up with the technological advances in our industries. In dentistry, there are dental implants, bleaching, teledentistry, and even digital impression techniques that are not specifically named in the North Carolina Dental Practice Act. To add new technologies to any regulatory boards, the Practice Act must undergo a procedure known as opening the act, which means simply to amend or revise the act through the legislative process. Obviously, boards, professional associations, and other boards that we deal with have some reluctance to do this because when this occurs, any special interest group might influence state legislators to change the Practice Act to favor their bottom line. Now for the audience participation part of the program. Think of some special interest that might want to affect your profession's laws in order to help themselves, to the detriment of the public whom you are pledged to protect. Have you thought of at least one? Come on.
Definitely dealt with this when I was a regulator. Absolutely, it's true. You're right.
Okay. Well, if everybody at least has one, thus ends the audience participation segment of the show. Then in 2010, the FTC filed an administrative complaint against the North Carolina board that said that the dental board was restraining free trade by sending the cease and desist letters, which it characterized as cease and desist orders. This is a very important distinction. This next went to an administrative law judge who denied the board's motion to dismiss on the ground of state action immunity. Then the board's next step was to be heard by the FTC court. They have their own court, which upheld the ALJ decision because to claim immunity, the board must be supervised by the state. The board argued that it was created by the North Carolina General Assembly, reported to the General Assembly, the governor, the Administrative Procedure Oversight Committee, and the Rules Review Commission of the General Assembly, and was clearly empowered to enforce the Dental Practice Act. The FTC argued that these safeguard provisions did not provide a sufficient level of state oversight, and therefore the board was not a state actor to which the state action immunity applied. At this point, the concept that the controlling number of the board's decision makers are active market participants came to light. And this is the basis for the FTC's distrust of most, if not all, regulatory boards. We'll get to the ensuing progression of the case in a moment. Just a little aside here. One of the FTC steps in its investigation was to send a 4 or 5 page detailed questionnaire to every dentist who filed a complaint about the tooth whitening and to every dentist who was a member of the board to determine their practice profits broken down by every conceivable procedure. And I was lucky enough to be in this group. Actually, the only statistic that they were really interested in was the profit from bleaching,
Mhm.
because they figured that dentists were making money hand over fist, and that's why they didn't want non-dentists cutting their prices and providing this service.
Gotcha.
Most, if not all, reported much less than 1% of their gross production was from bleaching. So the study did not appear in any of the FTC's arguments because it did not support their case. Next, the FTC lawyers deposed every member of the board and most of the board staff who served from 2006 until 2010. My deposition was 10 hours, but I heard that there was at least one deposition that went for a total of 18 hours.
Oh my goodness.
Yeah, my deposer had copies of every email that I had sent to any board or staff member. I felt that some of these were a little embarrassing, so you may want to be careful what you put in writing that may come back in discovery under the Freedom of Information Act. After my 10 hours, the FTC lawyer said that he might be interested in retiring to Asheville someday and that he would need a dentist. You can imagine what I thought about that possible scenario.
You were jumping at that opportunity, I'm guessing.
Well, not to say a dental term, I was chomping at the bit. But
Ah,
anyway, so now continuing with the progression of the case. The FTC prevailed in the FTC court. You can imagine that. And the court sided with the FTC on several important issues. First, public protection cannot be used as a defense in an antitrust case. Remember, the entire reason the board became involved with this was the issue of public protection. That argument was completely eliminated. The board's cease and desist letters were characterized as orders with the sanction of state authority, which is an interesting and confusing point. When sending cease and desist letters, the board was acting with state authority, but was not sufficiently a state actor when seeking a state immunity. In essence, the board moves from being a state actor in issuing the letters to a non-state actor when seeking the protection of state action immunity. The board moves back and forth, in and out of state action, but only the FTC can determine what role the board is filling. And three, the board members who are also licensed in the profession they regulate cannot overcome their economic interest in the marketplace and therefore make decisions based primarily, if not unknowingly, on their own self-interest. Now, these were what the FTC said.
mhm.
The FTC court decision was heard on appeal in the Fourth Circuit Court of Appeals in Richmond, Virginia. Each side at this level has 20 minutes to present its case, with the justices often interrupting with questions. A big sticking point here was whether the North Carolina board was a sovereign actor. Now we're starting to get into some of this legal stuff. The Sherman Antitrust Act, which basically limits competition, is modified by a court case about raisin farmers in California called Parker versus Brown. See, it's getting more and more complicated. Parker, as it is known, is a rather long decision, but suffice it to say, the Supreme Court of the United States interpreted it to confer immunity on the anti-competitive conduct of states acting in their sovereign capacity. Therefore, the Fourth Circuit decided that the North Carolina Dental Board was not a sovereign actor because it is not regulated by the state and cannot have state immunity. I am sure all the lawyers in the audience understand what all this means, but to the rest of us, suffice it to say that regulatory boards are still gray areas under the law to this date. Next, we appealed to the United States Supreme Court. They accept only a fraction of the cases that are sent to it, and they accepted our case. They felt it was important enough for them to make a decision.
Mhm.
So in October 2014, we were off to Washington to see the Supremes. Each side at this level is given 30 minutes to present its case, with the justices interrupting with their questions. Present were Justices Roberts, Ginsburg, Sotomayor, Kagan, Kennedy, Breyer, Scalia, Thomas, and Alito. The purpose of this hearing was whether to uphold the Fourth Circuit's decision in favor of the FTC. There are many Sherman Act antitrust cases, such as the Parker case, that were cited. There was much discussion that the dental board was composed mainly of market participants who regulated their own market. The Assistant United States Solicitor General from the Department of Justice, who argued the case for the FTC, suggested that the dental board be composed of retired dentists only, or lawyers only. Justice Alito responded to this with, "If I have to have brain surgery, I want a brain surgeon to tell me who is qualified, not some lawyer." I thought that was good. A recurring theme was that the state agencies controlled by active market participants must be supervised to prevent the market participants from confusing their own interests with state policy goals. State supervision is not definitely defined in their decision because they said it's flexible and context dependent, which suggests that this is a gray area in the law. Here's that phrase again. The Supreme Court recognizes that regulatory boards have authority over its licensees, but for unlicensed people, it is more restricted. This was ultimately the 36-page decision by a 6-3 vote, and the North Carolina Dental Board lost the appeal based on this. The 3 dissenting justices said that the Supreme Court misunderstands the doctrine of state action antitrust immunity that it recognized in the famous Parker versus Brown case. So I thought that was interesting. So now we get to the final order from the FTC, finally. First, the dental board can in no way direct a non-dentist provider to cease providing bleaching services. The board cannot communicate to a landlord that bleaching services by a non-dentist is a violation of the Dental Practice Act. But the board can pursue any administrative or injunctive measures against these providers and can continue to investigate allegations of the unauthorized practice of dentistry. Further, the board had to send letters to anyone who ever received a cease and desist letter, telling them that the board has no authority to tell them to cease and desist. The board was required for 4 years to file annual reports with the FTC about teeth whitening interactions, and the FTC can examine anything at the board office until the order terminates on 12/2/2031. So what has changed in North Carolina because of this case? The process of board selection and oversight has not changed at all. The 6 dentist and 1 hygienist board members are elected by the licensed practitioners in the state. Most state boards are appointed by their governor, but in North Carolina, this is not the case. The ratio of licensees to non-licensees on the board remains the same. However, the board accepts the ruling of the court and the FTC that the board is not a sovereign actor eligible for state action immunity. However, courts are sovereign and independent judges are not market participants driven by economic self-interest. Therefore, the board never proposes any solutions to those who provide unauthorized dental services in North Carolina. The board simply collects evidence through the investigatory process and files lawsuits for injunctive relief against those providing such unauthorized practice. In other words, now the North Carolina Dental Board goes directly to the court system to sue suspected non-dentist providers, which satisfies the supervision provision of the state action immunity from antitrust actions. So why did the North Carolina Dental Board pursue this tortuous legal path? We felt that non-dentists providing bleaching services was the unlicensed practice of dentistry, according to our Dental Practice Act. Here's a shocker. The board spent $3.2 million of its own money to defend this belief, and we can assume that the FTC may have spent a similar amount of our tax money to pursue their assertions. So ultimately, possibly $6.4 million was spent to determine that a dental board cannot send cease and desist letters. Money well spent. As with any legal matter, one must decide how much one is willing to spend to defend or pursue a lawsuit. When the FTC first filed its complaint, this is really interesting, and the dental board learned that the FTC considered the cease and desist letters to be a problem, we changed the letters to make it clear that the board had no authority to require any person to stop the provision of unauthorized dental services. Only a court could do that. The FTC, in its infinite wisdom, would not accept this voluntary change and insisted that the change be made only pursuant to an FTC order. At this point, the board resisted the intrusion of federal authorities into the practice of dentistry in North Carolina, and the question of state action immunity had not yet been settled. Therefore, the case continued. The settlement would have saved a lot of money and trouble, but we felt that this was the proper way to protect the citizens of our state. The FTC has had a problem with regulatory boards for a long time because of the restraint of trade problems. The matter is not anywhere near settled in the law. There is an ongoing case now, Smile Direct Club, one word, versus Battle, B-A-T-T-L-E. The Smile Direct Club, a form of teledentistry involving orthodontics, has sued the Georgia Board of Dentistry for restraint of trade. The Georgia court denied the board's appeal regarding their state action immunity. Here's that again. So the case then went to the 11th Circuit Court of Appeals in Atlanta, who decided just this year to hear the entire case from the beginning, not just the appeal. Interestingly enough, the FTC and the United States Department of Justice have filed an amicus brief in support of Smile Direct, and these federal agencies have received permission to speak at oral argument. The court hasn't issued its decision yet as of today's date, so this whole matter concerning regulatory boards is still evolving. And that's the truth.
Wow, thank you so much for taking us through that history. My goodness. And we do have so many questions. I know we just have about eight minutes left here. So I'm actually going to curtail some of my questions and dive right into audience questions. And thank you to each of you who have been submitting them throughout the chat. Incredibly interesting to hear this entirely from the board's perspective, because and all the research I've done on this, I've never really gotten that insider's view. So very, very interesting. And thank you for breaking it down for us in that way. So one question, and you touched on this a little bit during your chat, at some point in the process, did your board say, okay, you know, in amongst themselves say, okay, you know what, this isn't worth the legal cost and the battle. Let's just open up our Practice Act and try to resolve this through legislation instead. Like, did you ever kind of go back to the table, or was there kind of internal argument with the board members around that later on in the process when you realized that this was becoming, you know, millions of dollars worth of expense?
No, we really didn't discuss that, because from the beginning, when we were trying to be reasonable with the FTC and they were being totally unreasonable, you know, by our offering to change the cease and desist letters and admit that we don't have the authority to tell them to stop. The FTC wasn't satisfied with that, and they wanted to bring the federal laws, federal people into the state of North Carolina to regulate the practice of dentistry, and that's not something we could live with.
Mm-hmm. Gotcha. Understood. We have another question. To what degree was the initiation of the complaint, and secondly, legal action against the FTC through the courts to SCOTUS based on, one, the scope of the North Carolina dental practice versus two, actual evidence of harm to consumers with kiosk teeth whitening?
Well, can you repeat the first part of that question?
Yeah, no problem at all. So I think essentially what they're asking is, you know, do you think that the initiation of this complaint was about kind of how the North Carolina board was managing the scope of practice of dentistry versus the harm, there were consumers out there actually being harmed, you know, in terms of why you think this legal action reached to this level. I think ultimately it's, was there any proof that consumers were being harmed?
I don't think the FTC was at all cared about that. Their whole thing was restraint of trade and participants in the marketplace regulating their market. That was all they were interested in. In all of their deliberations and even at the Supreme Court level, our definition of bleaching was never mentioned.
Got it.
The bleaching was just an excuse for them to come in and show their power.
Gotcha. Yeah, very, very interesting, and great question from the audience. Thank you. Another question that has come in, how much of the board's sort of deliberation in terms of like what they were going to do in this legal process was kind of required to be done during an open meeting laws versus, could you guys kind of discuss any of this in closed session? And again, I know you're not an attorney, so I don't expect you to be up on the North Carolina open meeting laws, but were you able to kind of, as a board, privately discuss how you were going to address these challenges?
Whenever we received advice from counsel, that was always closed session. But our discussions of what was going on and where we go next, that was all in open meetings.
Perfect.
The advice from counsel was closed session.
Attorney-client privilege, that makes sense.
Yeah.
100%. Okay. I think we have time for maybe 2 more questions. We'll see. All right. This was one that was sent in advance. So thank you, Mark Bringelman. Is the real lesson of the US Supreme Court case about anti-competitive actions against non-licensed persons doing professional work? And his comment is, I mean, dentists can always regulate other dentists. That hasn't changed much.
Well, that's true. Dentists can regulate their licensees. Any regulatory board can regulate their licensees. What this whole matter centered around was regulating non-licensed people. And I mean, the answer to that is don't do it. Just go through the court system, let the court regulate them.
Yeah.
Go to your county sheriff, go to your local DA, and file a case and get injunctive relief.
That's exactly how my board started responding immediately. As just kind of, that's where our attorney advised us to do, was just stop sending out cease and desist orders entirely, and just seek injunctive relief against anyone who you feel is practicing at the time counseling without a license. So very interesting. And this kind of ties into another question that came in terms of boards actually carrying out their statutory functions. What can licensure boards do to better insulate themselves from this type of liability? And it sounds like part of it is just not sending out cease and desist orders. And again, I know you're not offering an attorney opinion, but that's an action that you guys immediately took, it sounds like.
Oh yeah, that was step one. And so I mean that's the main thing. Don't find out what, if you have state action immunity from antitrust, and the FTC said we don't. The North Carolina Dental Board doesn't have state action immunity. So find out exactly what that means to your board, and don't overstep the bounds that will put you in jeopardy of the Sherman Antitrust Act, and battle you on whether you have state action immunity or not.
Right. I think I have one last question that sort of encompasses several different questions that have come in at once, but I think really what everybody's asking is there anything that you feel like the North Carolina board should have done differently? And maybe a better question is, any lessons learned that you bring forward and any recommendations you have for boards in the future when you kind of look back on this and this experience?
I think the North Carolina board actually bent over backwards in the beginning of all this. And the FTC was not at all being compliant or flexible at all in their handling of this complaint that they filed with us. So, just like I said, when you either pursue or defend a lawsuit or a complaint, just figure out at the beginning how much money you're willing to spend and whether it's worth it, or if it's going to protect the public, if it's going to protect your values, go for it. But otherwise, maybe step back and take a second look.
Mhm. Well, I think that's a great place to end, because as we all know in the regulatory community, it all comes back to public protection and that being your first and foremost priority when you're doing anything as a board. So thank you so much, Dr. Feingold. I can't believe how quickly we hit our time today. I can't thank you enough for your time, and all the participants. Thank you so much for being so active and joining in on this conversation with all of your questions. You'll each receive a recording of this presentation today as well. And thank you for the nice comments coming through. I see them coming through chat. We appreciate you so much and look forward to seeing you next month. Dr. Feingold, thank you again. We can't wait until you are president of AADB. I know that's happening sometime in the future.
Thank you very much, Mary Alice.
All right. Bye, everybody. Have a great day.
Bye.